Yes, sir, and yes, ma'am. Two words that sparked a years-long battle when it comes to free speech and religious freedom. Shawnee State University professor recently won a big lawsuit after refusing to call a student by their preferred pronoun. Joining us right now, the professor at the center of this lawsuit, Dr. Nicholas Meriwether, and his attorney, Tyson Langhofer. Good morning to you both. Thanks for joining us here on the National Desk. Welcome.
Thank you.
Thank you.
Dr. Meriwether, after you answered a student saying, yes, sir, that student filed a complaint leading to a formal investigation. And ultimately, you did agree to call the student by their first or last name, but the university rejected that offer. So talk us through what led you to file this lawsuit.
Well, essentially, the student was demanding that I refer to him as female, and that was not something that I could do. I reject the ideology that he was proposing to me for both religious and philosophical reasons. I was, as you say, willing to use the student's proper name. Initially, the university agreed to that, but eventually they changed course and were going to require me to use those particular pronouns and titles that the student wanted. And so I had to file a lawsuit to protect my job, but also to stand up for the freedom to freedom of expression in the classroom for professors and for students.
And Dr. Meriwether, this was a three-year fight. The U.S. Circuit Court of Appeals for the Sixth Circuit actually ruled in favor of your case, affirming that you could sue the university for violating your constitutional rights. You got $400,000 in damages. What was the final agreement when it comes to what you can say, and what did you make of the school's decision to finally settle? Was this the outcome you were hoping for?
Well, it was the outcome that I was hoping for. The outcome that I was hoping for was free expression in the classroom for professors and students. This is an enormous win for all college professors, certainly in the 6th District, but I think throughout the United States. So that was the outcome I was hoping for. It was never about the money, and really it wasn't about the student either. The student performed well in the class, finished the class, got full credit. This was about whether a university can coerce or compel speech. And in this particular case, the Sixth Circuit ruled against the university. The university was trying to compel me to affirm an ideology. And that was exactly the outcome I was hoping for.
And when discussing this case, you just mentioned that the university often wanted you to contradict your Christian beliefs. Why was it so important for you to honor your beliefs throughout this situation? And is there any part of you that ever questions why you work for this institution, if that's the case, if they're asking you to go against your Christian beliefs?
Well, I do not question my being there. Matter of fact, I enjoy being there, and it's been a thrill to teach there. I think Christians should be in higher education, and I'm hoping this decision will make it possible for Christians to be in higher education with a clear conscience. The transgender ideology contradicts the fundamental teachings of the Christian faith. No Christian can, in good conscience, affirm anything other than the fact, that God created us male and female. Or created man and woman, male and female, and there's no way that a person born male can suddenly decide to be female and vice versa. So to affirm that would be to contradict the Christian faith, and I'm hoping I've made it easier for Christians to be in higher education.
Well, Shawnee State did comment on the settlement, and they said, quote, "Though we have decided to settle, we adamantly deny that Shawnee State deprived Dr. Meriwether of his free speech rights or his rights to freely exercise his religion. We continue to stand behind a student's right to a discrimination-free learning environment, as well as the rights of faculty, visitors, students, and employees to freely express their ideas and beliefs." Over the course of this lawsuit, it became clear that the case was being used to advance divisive social and political agendas at a cost to the university and its students. Tyson, I want to go to you next. Your response to this. What did you make of the school statement?
Well, I think, everything that we did demonstrates that we went out of our way to try to get this resolved prior to litigation. Dr. Meriwether agreed to call the student by the student's chosen name and just avoid pronouns. And yet the university is the one who was enforcing their ideology and decided to punish Dr. Meriwether, not because of anything he said or did, only because the university was demanding that he say something that he does not believe. And that's contrary to both the First Amendment and really the purpose of a university, which is to be a marketplace of ideas. The students are free to express their beliefs, and all Dr. Meriwether was asking for was the same right.
Tyson, what message does this outcome of this lawsuit send to institutions? And tell us what kind of precedent that this poses going forward when it does come to free speech or freedom of religion.
Well, the Sixth Circuit made very clear that every professor in every public university in all of the Sixth Circuit have the right to speak freely, and that the university cannot punish them for declining to speak a message that they don't agree with. So I think that this sends a very clear message to universities that they shouldn't be trying to impose this type of orthodoxy and force everyone to express the orthodoxy the university agrees with. And so we're hoping that this encourages many people, whether they agree with Dr. Meriwether or not, to continue to engage on this really important debate about what it means to be a man or a woman.
Dr. Nicholas Meriwether and Tyson Langhofer, we appreciate you both joining us here on the National Desk.
Thank you for having us.